You guys aren't free to leave. You guys aren't free to leave.
No, you're not free to leave, or you're all getting arrested.
Arrested for what?
Obstruction.
That's fine, but you will not question them without their attorney.
Hey, sir, come over here.
Hold
up.
Stop.
We'll talk.
Because he just snapped.
Okay, we will talk.
Shut up.
Stop.
I'll deal with it.
Come over here. What's going on?
Well, we were walking through, and I was sitting there. Me and my grandson was looking at the car. Then he was walking, and he tripped over the wagon. Right? I said, I told him before he got to it, watch out where you're going. And he bumped the umbrella. Everything was cool. And then next thing you know, he started saying something to my daughter. Then he calls my wife a fat.
Hit me.
And so that's when I said, what the are you doing, man? And then he's like, well, I'll you up. He's like, hit me. So I flinched at him. That's when he come at me, put hands on me. Then all I did was grab him, and we fell over the fence, and I had him on the ground, and before I could do anything, I had 3 of his buddies smacking me in the head and shit, and then we're trying to get out of there, and they're following us. He come back, sucker punched me again, hit my wife, hit my daughter as we're trying to leave to go home. They're pursuing us. I'm done with it, you know what I'm saying? I was done. I was trying to walk away. And they keep pursuing us. Period.
Okay.
You know?
Okay, so this all started over a bump into the cart.
Into the car, which wasn't a big deal.
Okay, you guys.
That huge guy, he keeps coming at me, and we're trying to leave. I'm trying to get the out of here and go home. That's where we were going when all this started. Was through our car.
You got hit?
On October 13th, 2024, Sandusky Police responded to a physical altercation inside Cedar Point theme park in Ohio. The incident raises 3 distinct legal questions: the limits of investigative detention, juvenile rights during field questioning, and mutual combat under Ohio assault law. Under Ohio Revised Code Section 2903.13, assault requires knowingly causing or attempting to cause physical harm to another person. Both parties in this encounter made admissions that create criminal exposure. The adult male from the opposing group allegedly struck a minor following a verbal dispute over an accidental collision. Under Ohio law, verbal provocation, no matter how offensive, does not constitute legal justification for physical force. That principle is established under State v. Deem, Ohio Supreme Court, 1988. The family's adult male admitted he threw a punch after being verbally challenged. That admission weakens a pure self-defense claim under Ohio Revised Code Section 2901.05, which requires a reasonable belief of imminent harm. The stronger defense available to him is defense of another under Section 2901.05, subsection B, specifically the defense of his minor child who was allegedly struck first. The sequence of events matters enormously here. If the teenager was physically attacked before the father intervened, the father's use of force may be legally justified. If the father struck first in response to words alone, it is not.
Hey, look at his nose. Let's go over here and talk real quick. I'll talk to you.
Remember how spindly it was making it?
How'd you get hit?
You want the full story?
Yeah.
So basically, I was goofing around.
Well, don't walk up on me like that first.
It's my dad. It's my stepdad, pretty much.
He with me. I got you, but that's not. This isn't me versus you. That's not what this is.
I never said that, but I'm
okay. I got
He's
you.
mine.
Okay, that's fine. I'm getting his story.
That's
himself.
cool. He's mine.
Okay, so I'm gonna talk to him and just him.
Yeah,
you guys can walk over there.
It's not him
Okay,
because
that's fine.
his party.
I won't take your story. Have a good day. What do you guys have?
I just got it. I'm out at 79.
Hey, what do you guys have?
With the fight?
Yeah.
Come on, let's go.
So I just got a video. They're sending it to my personal.
Do you need anything else from us? That's my husband, and the one in the red is friends that I take ownership over.
Are you trying to pursue anything?
No.
No, we ain't trying to pursue shit, but I want this for my kids, bro.
Oh, it's not a pursuit. I mean, I'm not gonna make. But
out of here, bro.
Let me be honest with you.
Because I just want, if you were, I just want his story first. Then I can talk to everyone else.
I get that, but when we're walking through, literally, I mean, granted, a teenager does their teenager shit, and I pulled them back.
I got you.
But then all shit broke out. I lost my flip-flops, lost my shoes, you know what I mean? Because my son is getting hit by a grown man. Okay. And here's my thing. If they leave, it is what it is. It's a story to talk about on Facebook. But
what happened? Why would he get punched, though?
So he was walking, and he tripped over his shoulder. And he said, my bad. And the dude turned around talking crazy. He said, watch who you're talking to.
Is it a grown man?
It was a grown man.
Oh,
grown man.
Okay.
He tripped on, the walker, stroller, wagon, whatever. He tripped over. He said, my bad. And dude turned around and started talking crazy. Now, granted, I will absolutely admit my teenagers' anger issues were not great. He turned around talking crazy. They went in the grass and I'm 3 feet behind him.
In the grass?
Dude, it was a whole thing.
And just started.
He hit him in the face and threw him on the dirt.
Said something about me bumping the stroller. I said something back, kept walking. His girlfriend in front of me said something. And then, I was just like shit like that. And then she turned around. She was like, my boyfriend right there, he's gonna beat your ass, da-da-da-da-da. And he just walks up. As soon as he walks up, straight goes like this. I move his hand like this. I go move his hand off of my stuff. As soon as he does that, he grabs right back up, and then we just go over the fence. And then he's literally holding me like this. Literally just like that. And then I'm just sitting here struggling to get up. And eventually, the only reason why I was even able to get up is because my friend over here, he's the one I came in, was trying to break it up and stuff. And that's when he started swinging on him. And that's when it was just like a big ass bro.
Okay, that's enough.
Who broke it up?
Look, sit down. Please sit down. It's okay. We got it's about lawyers right now. Let's go.
With my hoodie.
Look, the four of you, they'll say not one more.
Not one. Not one.
You guys aren't free to leave. You guys aren't free to leave. No, you're not.
You're not free to leave, or you're all getting arrested.
We're leaving the park.
No, you're not free to leave.
Sit down.
Sit down.
Arrested for what?
Obstruction.
At approximately 5 minutes 37 seconds, officers declared multiple individuals not free to leave, threatening arrest for obstruction under Ohio Revised Code, Section 2921.31. This is where the encounter raises its most significant constitutional concern. The Supreme Court in Terry v. Ohio, 392 United States 1, 1968, established that an investigative detention requires reasonable, articulable suspicion specific to each individual detained. Reasonable, articulable suspicion cannot be applied to an entire group collectively. Officers must identify which specific individuals had direct involvement in the altercation before restricting anyone's freedom of movement. Detaining bystanders with no established individual involvement under threat of obstruction charges exceeds what Terry permits and approaches a Fourth Amendment violation. Furthermore, under Florida v. Bostick, 501 United States 429, 1991, a person must feel free to decline an officer's request or terminate the encounter for it to remain a consensual contact. The threat of arrest eliminates that voluntariness entirely.
Wow.
Which you would go to the county for.
Sit down. Don't say nothing. Don't say nothing.
Were any of you involved?
No, you don't need to talk to them without their lawyer.
No,
don't
get
touch
out of
me.
my face. You're going to jail.
Excuse me.
Get out of my face.
I am their guardian.
No.
Are you their legal guardian?
Yes.
No.
Then we need all their information.
That's fine, but you will not question them without their attorney.
Oh, Chief, you would not.
Gerard, move. Without their attorney. I request an attorney.
Then finish giving us our
I
information.
request an attorney.
Then finish giving us.
I request an attorney.
You're under arrest. Nope. It's all going with it.
Got an attorney.
Enough.
Because I promise you, I'm finna sue all you.
Get in the line. This could have been all.
They hit my kids, bro.
I'm not doing that.
Gangster.
And then these children are going to have nowhere to go.
No, it's okay.
It's okay. It's okay.
Please, I need
It's
you
okay,
to please
man.
chill out, please.
Man, lock me up.
No, it's
No.
okay. Stop.
Man, my kids.
The second constitutional issue arises when the adult guardian asserted, quote, "You will not question them without their attorney." That assertion was legally grounded. Under Ohio Revised Code Section 2151.352, minors possess the right to counsel before law enforcement interrogation, the Supreme Court in Regalt, 387 United States, 1, 1967, established that juveniles hold full constitutional protections, including the right to counsel in proceedings that may affect their liberty. Officers were not conducting a formal custodial interrogation at this point. However, once a guardian clearly and unambiguously invokes the right to counsel on behalf of a minor, the constitutionally cautious response is to acknowledge that assertion and pause substantive questioning. On the use of force continuum, no physical force was deployed by officers in this encounter. That outcome is directly attributable to the verbal de-escalation technique used by the primary officer at approximately 7 minutes into the footage. Rather than issuing commands, the officer appealed to the subject's parental identity, reminding him that continued resistance would result in arrest and leave his children without a parent present. Under the Graham versus Connor standard, 490 United States, 386, 1989, the reasonableness of any force option must be judged against the totality of circumstances. Where verbal de-escalation resolves a situation, no force is the most legally defensible outcome. This exchange is textbook. It demonstrates that effective communication is the first and best tool in the use of force continuum, not a fallback, but a primary strategy.
Stop. Stop, sir. If you don't calm down, you're going to leave them with no parent, and then they're going to go, too.
I've already explained to you what's happening, and you're making it worse.
Please, just talk.
Breathe, man. Calm, be smart in the situation that's going on right now.
Look at me.
Be smart in the situation.
Drive.
You're talking about your kids. You're about to leave them because you got to go to jail. That's ridiculous.
Because they hit my
Stop. Think about it. Think about it.
Please stop, please.
grown man is hitting the
But
child.
They didn't
So-
get that story. That's
Yeah.
They said they got an
But they
SP started and it was hitting on them, and then it
I got the whole story, like
Yeah, so
down to the last bit.
now what it's kind of being explained to me is,
he hit.
all right, he walks into the walker, okay? He says something. Did you apologize for it or
Yeah,
whatever?
I literally said after I hit the car, I was like, my bad. I was
Okay.
like, my bad.
Look.
And then I walked away, and that's when he whipped my shoulder
It was
back.
like this, and then he was like, my bad, and then the dude, he was like, watch where you're walking, and then he was like, you watch, and then he was like, you watch where you're walking, and then he just kept going, and then...
And that's when his girlfriend was like,
He was like, she was like, you shouldn't have walked into the damn wagon or something. And then he was like,
She's
Like, you can
the
see
one-
all the grass and dirt on me.
Okay.
the dude
But
walked
Will
up
was saying,
we're
oh,
gonna get- we're
and I
getting
bet
contact
you
with
he's
your
saying,
mom,
oh
whatever.
yeah, he punched me, he assaulted me. I
Wait,
bet
what do
you
I
he's
look like
saying-
as a kid running up on a grown-ass man punching him? Like, how is that
I don't
even...
know what he's saying.
I didn't
but they
get
can't
his
tell us that.
I didn't get his side of the story.
Officer Williams, where is he at right now?
Ejected. They got ejected.
I want my wife back, bro.
So
Where is she being taken to? Because she was part of it.
So I just saw that it looked like the kid in red kind of tripped over the wagon.
right?
And then the dad there was some words exchanged. I did not hear the words that were exchanged.
They were arguing though.
Yes, there were some arguments, and I saw the
Hey,
dad kind of
it's Williams.
push
Are you
the kid.
taking her to the county or?
I saw that
And then
part.
there was
of the video.
there was a physical alteration.
Yeah.
And then there was some jumping over the fence, some additional hitting, and then that was basically dad walked away. The mom stepped in and was like, just walk away.
Yeah.
But that's
It sounds
basically.
like he was more so assaulted. There's a separate witness here talking about it right now. So your wife is going to be up front, so we're just all going to walk up front, and then we'll meet her up at the flagpole at the main gate.
You need to use the bathroom.
520 station.
520, go ahead.
233 and I will be escorting 527 to the
At the time of this analysis, the outcome of any criminal charges or civil proceedings remains unknown. Based on the consistent accounts gathered on scene, including from an independent third-party witness, the opposing adult male faces the greatest criminal exposure under Ohio Revised Code Section 2903.13 for assault on a minor. The family's adult male faces a more complex analysis. His admitted punch without clearer evidence that it came after his son was attacked sits in a legally ambiguous space between lawful, defense of another, and mutual combat under Ohio Revised Code, Section 2917.11. The primary officer receives a B. His witness management and de-escalation were exemplary. However, he did not challenge the blanket detention order applied to the group, a Terry violation that lowers an otherwise strong performance. Secondary officers receive a B-. Crowd containment was effective, but the group detention threat lacked the individualized suspicion required by the Fourth Amendment. The adult male from the family group receives a B-. His account was consistent, and his cooperation with officers ultimately sound, but his self-admitted punch exposes him to assault liability, regardless of provocation. The teenager receives a C+. His apology after the collision was appropriate, but his continued engagement in a confrontation with an adult male rather than retreating placed him at unnecessary risk. The guardian receives a B+. Her invocation of juvenile counsel rights was legally accurate and constitutionally grounded. Asserting rights even under pressure is the correct response. 3 takeaways from this incident. First, apologies must be accepted. An accidental collision followed by an immediate apology creates no legal basis for physical retaliation. Escalating past that point exposes the responding party to full criminal liability. Second, know your rights before you need them. The guardian's invocation of juvenile counsel rights was effective precisely because she knew the law. Ohio Revised Code Section 2151.352 exists to protect minors in exactly this situation. Third, in a mutual combat scenario, the first party to disengage and attempt to leave holds the stronger legal position. Pursuing a retreating opponent eliminates any claim of self-defense and transforms the pursuer into the aggressor under Ohio law. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.